Hello, everybody. This is Jeremy Evans, the host of the California Sports Lawyer podcast and a entertainment media and sports lawyer based in California. I am the immediate past president of the California Lawyers Association, which is the largest bar association, or at least one of the largest bar associations in the country, if not the world. I also serve on the Rose Bowl Legacy Foundation Board of Advisors, and I'm also faculty in an adjunct fashion for a couple graduate sport management programs where I teach sports law, and that is at Cal State Long Beach in California, and of course, American Military University. And as I mentioned, I have a podcast that I do a weekly on the Believe Network, and then of course I write a weekly column. So as you're looking at this first screen, the only thing incorrect on the screen is that I'm the past president, immediate past president at California Lawyers Association. I'm the current president at the California Lawyers Foundation. So I'm doing this presentation on behalf of the U.S. Virgin Islands Bar Association, and really just happy to be with you. I made this presentation in person a couple of weeks back at the conference there, but obviously happy to record the conversation here now for each of you. So that's what we're going to be doing for the next hour or so. Um, Maybe a little bit less than that, but this is sort of presentation on what is sports and entertainment law, and really how to make an impact in the space as an attorney. So let's um, let's let's get into it and see um, what we can talk about today. So, what is sports law? Well, sports law is um, really dealing in possibly two things when you're talking about the core of what sports law is. It's talent, it's agents, it's attorneys, it's sports teams, it's leagues, NCAA, it's universities, it's conferences, it's Hollywood, with content and broadcasting. It's sponsorships and it's endorsements, it's broadcast deals, that sort of thing. And of course, all under the guise of contracts, right? So sports law really is contracts and intellectual property. And intellectual property being copyright and trademark, for the most part, licensing, that sort of thing, and licensing copyrights and mostly copyrights and then some trademarks here and there. And then in all of this context is this idea of deal making, right? So talent agencies, there's various state laws on talent agencies and how do you become a talent agent. Obviously, if you're a part of one of the big five, Major League Baseball, National Football League, National Hockey League, Major League Soccer, National Basketball Association, and um, let's see, I think, did I say Major League Baseball? So the big five: MLB, NFL, NBA, NHL, and MLS. Those are the big five. And if you're a part of any one of those, you also have to register, and generally have to take a test and become a talent agent or certified advisor or whatever the title is for each sport, to go through that process. Of course, the laws on sports law, pretty rare. You have NIL, name, image, and likeness rules in about 30 different states now. Um, and then you also have, some gambling. If you want to connect that to sports in the sense that that could particularly be called sports law, if you will. It's more gaming law, but that being said, that's sort of what it is. And then in California, you have a Talent Agencies Act, which is similar to what they have in New York, which requires that if you're procuring employment for talent, so let's say entertainment talent to be more specific, which we'll get into, you have to have a talent license to do that. So that's sort of the layout of what sports law is. Now, look, you may also have a situation where sports law could be family law, it could be a host of different things in that regard. But um, ultimately, when you're talking about what true sports law is, it's contracts, it's intellectual property, it's deal making. So, just to give you an insight into that. And of course, entertainment would be somewhat the equivalent. It's really contracts, it's intellectual property, but just in a context of creating content, distributing content, is really what it comes down to, whether that's for music or films or television or what have you. So when you're talking about sports law and sort of growth in the industry, it's really just led to more sports, right? I think broadcast rights have sort of opened up player rights. And then those two things combined have really led to social media and special purpose acquisition companies and public investment and private investment and this sort of thing. And ultimately with more social media and this growth of streaming, you've had an expanded audience, and it means more money, and it means an increase in valuation of teams, all sort of under the sort of purpose of capitalism. As sports continues to grow, it also moves away from older structures. You got new leagues being created, and the rules are being changed. Athletes are getting younger, deals are happening at a younger age. The largest contracts are now being brokered, and things just continue to grow. And of course, this is saying a lot when you're looking at the history of sports, right? Because this was a situation where, it used to be that a team would essentially control a player for its entire career. And now that's changed, right? And there's some movement in that. Curt Flood is a big reason for that. He was a St. Louis Cardinals baseball player, outfielder, a very good one. And he was about to be traded to the Philadelphia Phillies, and he refused. And the team owner and general manager, were kind of surprised. Like, well, we sort of control your rights as a player, so really you have to play here. But there was some litigation, and ultimately that led to the Messersmith case for free agency. But these men really sort of created free agency as we know it, and it really opened up some terrific opportunities in terms of that for players to where we're at today. Of course, social media has changed everything in terms of name, image, and likeness, in terms of advertising and investment. It's really created a personal broadcast channel for individual athletes and entertainers. So that's sort of the lay of the land, if you will. So why is sports law important? Well, just to give you an idea, in 2018, the North American sports market had a value of $71 billion. I would venture to guess that's probably even closer to $100 million now, particularly after the pandemic. And it's just so interesting, because when this statistic was taken, the expectation was sort of given as what it might be in 2023. Ultimately, yes, the pandemic happened, but sports has only continued to grow, and really even grew in some sense during the pandemic, because all eyeballs were on the television because people weren't out and about, right? So it continues to grow. It's an area of the market that has not really seen slowing down. So that's something to keep in mind from an investment standpoint if you're looking at that. Although this is not investment advice, but sports continue to grow. They're also very expensive. This kind of gives you some food for thought as to the market size of the global sports market from 2011 to 2018. Continues to rise. And this probably dipped a little bit during the pandemic, but this is ultimately sort of the idea of where sports is at. And with the U.S. sports market, this kind of gives you an idea of how big it is, about $80 billion. When you combine it with entertainment, it jumps up to $720 billion. So as big as sports is, entertainment is that much bigger. And when you combine the two, we're talking about really $7 trillion. I mean, it's an astronomical number in terms of how big some of these markets are. And when you think entertainment and sports, we're talking about all of Hollywood, all of Bollywood in India, in terms of the global market, all of sports, cricket, the NFL, international soccer, all these things, right? So sports and entertainment are huge markets. So, kind of want to go through a deal chart here and kind of give you an idea as to how deals are sort of broken down, right? And by the way, when we get to the end of this sort of short PowerPoint presentation, I'm going to go through a few different topics that are on my list that are not on these slides. But this slide presentation is more meant to give a kind of an overview of what the sports entertainment industry is all about. So when you're looking at this deal chart for endorsements and sponsorships, and frankly, this could be applied to other areas, but you essentially have, on one hand, you have the talent, right, and or the celebrity or whatever, the content or sort of particular document that needs to be created from sort of talent, right? To say, all right, talent is worth this much. This is what we have. And on one side, you'll have the agent or the attorney that's sort of going to negotiate this deal. On the other side, you're going to have the team or the brand or the advertiser or whatever it is to sort of help, going to be offering the deal, offering the money, offering whatever it is. Now, keep in mind that from the talent side, they're really only going to receive three things in any deal. It's either cash, product, or equity, right? And when you're looking at this, if you're brokering a deal, with, let's say, an apparel company, you're likely to get some product for free, right? Shoes, shirts, this sort of thing. If for example, if you market toasters, you're likely to get, toasters for free, right? Equity piece would be like if it's a startup company or they're brokering a deal together with an athlete that's very well known. And of course, cash is always, an opportunity to where cash may be given to broker certain deals. On the team side, it's all about authority, what deal they can offer, what one of the three buckets or all three buckets they can pull from to make the deal happen. And for them, it's all about partnerships. It's about investment. It's about buying into something and buying into a player and having that player sell something and advertise. And of course, look, this is important because, often why I would negotiate these deals, whether I'd be on the player side or the entertainer side or the studio or team side or whatever it was, I would always, sort of sit back and say, look, this deal needs to be somewhat easy to get out of. And both sides would kind of look at me and say, well, why would you want that? And I'd say, look, you ultimately want the teams to do something together, or in terms of you want the sides to do something together. You want them to work together. You want it to make sense. And if the two sides don't like each other, it's not going to be a good endorsement or sponsorship deal or good contract in general. If you're promoting a product or a service, you're going to want the person or thing to, use that product and to enjoy that product and to support that product. So just something to keep in mind, for this. So, as we look to this, and I sort of had this funny map, chart, if you will, on the right, where it's talking about, dips in markets, particularly on the white line there. Obviously, this is not a scientific chart, even though the asterisk says that. The point is to make is that sports is continuing to rise as we looked at the past, sort of structures, right? And there's a few things that I want to talk about sort of for the rest of this presentation in the sort of sports entertainment, context. One of them is going to be name, image, and likeness. The other is going to be sports gambling. The other is going to be NCAA structure and what that looks like, and maybe some of the ongoing litigation and what conference realignment might look like. And again, as it says on the screen, we'll also be looking at, best practices in negotiation, retaining clients, retainer structure, and then maybe closing with the future of the entertainment and media and sports business. And I might throw some other things into this discussion as they come to mind. So looking at NIL, what is name, image, and likeness? And during the in-person presentation, this was a hot topic. Well, name, image, and likeness is, or NIL for short, is the ability for a person to make money off of their person. So whoever they are as a person is the ability to make money off of that. And going back to, the early days of college sports, this was really student athletes played a sport, and there was no talk about paying them. There was no talk about anything like that. But this really all changed when these universities and conferences began to bring in lots of dollars from television, sponsorship dollars for, shoes and apparel deals and this sort of thing. And then, of course, if they're using like a Microsoft Surface or an iPad, deals for that as well. And of course, then there was, of course, the EA Sports games and some of the video games that came out that had strong resemblance, almost identical resemblance to some of the athletes. And so I think one of the points was, well, how do we, how do we handle this, right? And there was some litigation, particularly with Ed O'Bannon, who was a former UCLA basketball star. And he sued, saying, EA Sports can't have this game that is benefiting the NCAA and also benefiting EA Sports for our name, image, and likeness, and we're not getting paid. This goes beyond the pale, so to speak, of just playing a sport in college. And of course, as sports became more popular and there's more money involved, more training got involved, coaches got paid more, and more time is being spent on the field, right? So then eventually came the claims of, well, maybe this should be employment. And there's actually a current, litigation going on right now against USC, the University of Southern California, the Pac-12 conference, and the NCAA, claiming that there's this unfair labor standards issue where these college athletes are being classified as, essentially independent contractors when they should be classified as employees. That's the argument anyway. And on the podcast that I did this past week, which would have been December, here early December, I'll get you the exact date, but give me a second here. Would have been December 19th, 2023. And then December 18th, it was a column on the same topic about breaking down, this sort of employee status, right? And what that means and the effects that could have on college football and college basketball. And so because of all this litigation, there was a Northwestern case where, that the players tried to unionize. All these things with the growth of social media eventually led to the athletes and the industry really saying, we should change this. So state legislatures came along and said, let's pass NIL rules that allow student athletes to make money. There's only one problem with that. A lot of these laws already existed on the books, either through court cases, through case law, more specifically, and through, for example, in California, the Right of Publicity Act was on the books going back to the 1970s. But ultimately, the NCAA rules did not allow for this. The NCAA rules said specifically, you cannot sign a contract and you cannot receive anything of value. And this was interpreted so strictly by the NCAA and compliance offices across the country inside universities and colleges that if you even received a ride home or a pair of shoes or anything, that was considered a violation and had to be reported. So ultimately, these states passed these laws, and then NCAA president at the time, Mark Emmert, came in and said, California, which was the first state through the Fair Pay to Play Act with NIL, said, California's really forced our hand and we're going to have to relieve those rules. And so now athletes can make money. So that ushered in, as of July 2021, ushered in this new NIL era, which was also combined, by the way, with the transfer portal, which really created this Wild West and competition of players transferring and coaches offering certain things. And then collectives are being created, which are essentially community-based money collectives that people put money in, and then that money goes out to the players. And now there's questions as to whether the universities will be managing this. A lot of new businesses have been created from this aspect. It's really just been an entire growth of the industry because of NIL. And of course, even women's sports have gained from this, because when you're talking about social media, it's not about your statistics. It's not about whether you're male or female. It's about what's your engagement on the platform with social media. And oftentimes the women are more engaging from a data standpoint than the men are. And so we've had some women that have made money as well in NIL. There's been some calls to make some changes and that sort of thing, but that's currently the market, and that these athletes can essentially make money or pull from those three buckets we talked about, product, equity, or money, right? So that's the current situation. And of course, NIL is complicated by the fact that we live in a market with now sports gambling, which we'll go over in a second, and the NCAA conference realignment. So sticking to sports gambling for a minute. Now, normally you'd say, well, what's sport gambling have to do with college sports? Well, the problem is you can still bet on college sports, right? And this is a huge industry. Well, the PASPA Act was passed back in the early 90s, I think 92 or 94, I think. And essentially it said that beyond the current states that had sports gambling, they could not go beyond that. That it was essentially the United States was saying, we are going to be a dry country, so to speak, when it comes to sports gambling. So kind of like a similarity to prohibition, if you will, where sort of it's the limitation of the distribution of alcohol. But, ultimately that was lifted after, I don't know, what was it, 10 years or so. And then ultimately it was referred to as the Great Experiment. I think sports gambling can be sort of put in the same category in that, sports gambling, once PASPA was ruled unconstitutional, and back in 2018, from the standpoint of the idea of commandeering, where these states had sued saying you cannot commandeer a state to do or not do something where the federal government has not pervaded that space, right? So federal government was not involved in sports gambling. It was essentially involved in, really nothing to do to that. And so when this case was overturned on the commandeering argument, then the idea was that the states were allowed to open up to gambling, but they had to do it through some sort of structure, some sort of licensing threshold, which of course about 30 or so states have done to this point, with Texas, California, and I think Texas and California still holding out, and I think Florida as well. I don't think Florida has passed a sports gambling law yet, and I may be wrong on that, but Texas and California for sure. And so, and of course, from what I understand, sports gambling is a big sport in or interest in the Virgin Islands. And of course, a further interest is horse racing. And of course, there's a new horse racing league that's coming out. I think it's the United Horse Racing League or the National Horse Racing League or something like this. And the idea is that they're going to race older horses. So instead of being within the first 3 years where there's higher injury levels, they'll race older horses where it'll be slower but less cause for injury. And they're going to create teams from this as well. So very interesting. So sports gambling comes out, creates this huge market. I think there's going to be some pushback on this. You look at what's happened in Europe, particularly in England, where you had sports sponsorships with gambling companies and all this. And ultimately, it leads to impropriety because the teams don't know what to do when something goes wrong. And of course, there might be rules in play, but it just creates an environment that is just not the best, right? And so we're going to have to continue to monitor that because I think there's already been some pullback on some of these sports gambling deals. Although Mark Cuban just doubled down on this and sold a stake of his team to the widow of Sheldon Adelson, who was owned the Las Vegas Review-Journal and was big in Las Vegas in the gaming industry, and or at least in the news industry, but relatedly to the gambling industry. And essentially, the heir purchased a stake in the Mavs franchise with the hope that eventually sports gambling will be passed in Texas, and they'll be able to create a huge sort of sports gambling entity for the Mavs with a new stadium or arena, if you will. So we'll see what happens there. And sort of circling back a little bit, these things all combined, NIL in 21, sports gambling in 2018, a lot of litigation that's going on, players getting paid through NIL. There was the Alston case, which said that schools could not, essentially in a 9-0 decision written by Justice Kavanaugh, that schools could not limit benefits. That essentially they had colluded to limit the benefits of student athletes. So once these things are all lifted, then of course now there's some competition created, and the Overtime Elite League comes out and says we're going to create a high school league where players can attend high school from an education standpoint, but then play in this private sort of league and get paid. Of course, the question remains is whether colleges will accept that. Would you be able to go to college after making money? Unlikely, because you're almost you're really being treated as a pro. And then of course you have the G League, which is formerly the Development League for the NBA. And then of course none of this is of issue in sports like Major League Baseball, the National Hockey League, and Major League Soccer, and in international soccer, because, well, first of all, there's no college sports overseas, right? So this is specifically an American issue. But when you're looking at this sort of point of, sort of college sports in the United States, there's clearly been some, realignment. There's been some changes based on all of these different things that have happened. And so now you have, schools like UCLA and USC leaving for the Big Ten, along with Oregon and Washington. And then you have sort of calls for a 64-team conference by UCLA's head coach Chip Kelly, where all football would play in sort of a national conference. And then the other sports like basketball and baseball, which play more games, would play sort of the more local teams that are in the traditional conferences. Again, that's one model. Another model that's been presented by NCAA president Charlie Baker now, who's a former governor of Massachusetts, had made this comment that, we should pay the players $30,000 a year, male and female. Of course, inside all of this is the Title IX issue, which essentially calls for equal pay, would call for equal treatment, right? And this doesn't mean you have equal sports in the school, but it does mean that there's fair treatment. And so, of course, if schools start getting involved, and NCAA gets involved with paying players directly and not paid based on a job or social media post or what have you, you're going to come across the problem of being in a situation where, you might have to follow this sort of equal pay issue and be concerned with Title IX. So where does this go from here when you're looking at sort of, this conference realignment, right? Well, I think that, first of all, we're no longer going to have a Power Five, at least is the way it's structured. Power Five being the SEC, the ACC, the Big Ten, the Big 12, and the Pac-12. The Pac-12 is essentially in existence with a name, but it's really now the Pac-2 in terms of numbers, because you have Oregon State and Washington State. They just signed a deal today with one of the Western conferences to play sports, but then they signed a deal also with Mountain West Conference. So I think it was the WCC for the WAC, I think Western Athletic Conference, and for all other sports except football, and then football's with the Mountain West. What's interesting is that the number statistics for wins and losses in football will count towards the Western Athletic Conference as opposed to the Mountain West, which somewhat makes sense, right? Because it's really just a scheduling thing. It's not a sort of you're going to join our conference thing. But that creates some interesting things. I mean, one, sort of looking at the bowl games, what happens to the bowl games, college football playoff, which is a private entity, not related to the NCAA, being expanded to 24 teams in 2000 or 12 teams in 2024. And of course, this is really related to dollars, right? And really matchups, because if UCLA can play Ohio State and Michigan State, these are huge television games. And also the money wise, when you're looking at the Pac-12, when it was in existence, they were making anywhere between 25 and 40 million a year. With UCLA now joining the Big Ten, they may make somewhere between 70 and 90 million dollars, right? So it also opens up recruiting, because now athletes who are in the Midwest who want to play for a West Coast team will have the opportunity to travel back to the Midwest and to the East Coast, right? Because the Big Ten conference runs essentially from New Jersey to California. And so the first conference in my knowledge to do that, ACC eventually added Stanford and Cal, but the ACC doesn't have any Midwest schools, right? So very, very interesting about how this is sort of played out. And then, of course, from, a policy standpoint, the Power Five, or now to be the Power Four, already have a lot of autonomy. So that may continue to grow. As we mentioned, we talked about the Chip Kelly argument about going to a 64-team conference, with the other sports playing in sort of more of the local games. We live in a fascinating time, to say the least, with college sports, and I think there's only going to be continued challenges in this, and continued benefits too. These are not bad things, but clearly are going to open up some opportunities, I think, for the future of entertainment media and and sports. So, one of the questions that was brought up in person was this idea that, well, what happens when, and I'm going to put up my contact info on the screen for everybody and a link to the podcast and also to my articles. But if you just Google California sports lawyer, those things will pop up. And the podcast streams on all the major platforms. So, not hard to find: Spotify, Amazon, Apple, all that stuff. Well, it's interesting because, one of the questions that was asked in the in-person session was, well, should coaches have this ability to ultimately recruit players with NIL money? And I think traditionally, no, that should not be the case. But I think it definitely has happened, and it's something that will probably continue to happen until the NCAA decides to regulate it or not. I think the key component in all of this is the NCAA. Congress is very unlikely to pass a law that covers all 50 states, talking about and territories, talking about some sort of regulation on the NCAA. It's not going to happen. It's a private entity. It's the commandeering issue again because of NIL laws now in these individual states, that sort of thing. It's sort of the reverse of the sports gambling, PASFA Act, right? In terms of one coming before the other. So, again, from a traditional setting, no. Coaches should not be able to use this. And then, of course, the other question that's sort of come up is, with collectives and how money is managed. And, it's interesting because a lot of these universities have gotten into helping managing some of these opportunities with these athletes. And that's a scary opportunity because, ultimately, at what point do the universities sit back and say, oh, well, we want to take a percentage of that money because we're managing that? Or at what point do they become the agents and the managers, right? As they're sort of helping to broker these deals. So this is all not, sort of, great for, for the NCAA. And of course, the NCAA really should have a bigger role in this, and they should be setting the rules and the standards. And I think, frankly, they probably feel powerless and they probably feel like they can't make any moves. But here's the thing. They do have the power because as long as those schools are a part of the NCAA, they're going to be regulated by them. And maybe the argument is, well, if we leave or if we have more established rules from the NCAA, maybe those schools leave. But they do have benefits from the NCAA, and one is coverage. The NCAA has been claimed, to be sort of been the poster child, if you will, for what people might refer to as bad behavior. I think maybe it's more bad luck in that, ultimately, it's not the NCAA that sets the rules on one and done for basketball or the junior rule for football, meaning that it's the NBA that requires athletes to go to college for 1 year before they can be drafted, unless they go through the Professional Pathways program, which is through the G League, or they get drafted overseas. And then in football, you have to be at least a junior before you can declare for the draft. And, famously, Mike Vrabel, who's the head coach of the Tennessee Titans in the NFL, had made a comment about this one time when asked by a reporter. And he's a very open guy. He's never really held back. And I think people love him for that reason. But he had said this point that when a reporter asked him, well, hey, how come the NFL doesn't have a minor league? And he said, what are you talking about? We do. It's the NCAA. And maybe it was a slip of the tongue, but the reality of it is that the NCAA is the minor league for basketball and for football. And basketball has less of a problem because they have a minor league established. The NFL does not. But one thought is that with the merger of the XFL and the USFL, two sort of spring leagues, is that could essentially become the minor league, so that you could have maybe even divisions in that league, to where you can have folks who graduate from high school compete, and then you might have a higher league or division within inside of that. Because the one big complaint and concern with professional football compared to college football compared to high school football is size and speed. The players are a lot bigger and the players are a lot faster in the NFL, and surprisingly fast. When you're on the field and you're seeing this sort of go down, it's a fascinating spectacle, to say the least. So again, we sort of live in this sort of fascinating time, in sports and entertainment. And one thing that I want to turn to a little bit is the Talent Agencies Act, and talking a little bit about entertainment. So the Talent Agencies Act is something that's very specific to, let's say, California and New York. And again, as I mentioned earlier, it requires that if, somebody wants to procure employment, so get, sign a contract, get a job, whatever it is, book a gig for talent, they have to be a registered talent agent. And there's this famous case in California where this gentleman represented a sportscaster, and that sportscaster decided after 20 years of working together that he was no longer going to pay his lawyer. And they had an interesting pay structure, which provided that the lawyer would receive a percentage of every contract that the talent signed, and that obviously that the lawyer negotiated. Well, as the talent got older and made less money, or maybe they got into financial trouble, there might even been a bankruptcy thing going on, the athlete decides, or not the athlete, the broadcaster decides not to pay the lawyer. The lawyer sues. Case is removed to the labor commissioner, which controls the Talent Agencies Act. And the claim was that, well, my lawyer wasn't a registered talent agent, even though he was a registered lawyer and was licensed by the State Bar of California and was doing all these things. And lawyer would even potentially make the argument that the agents were engaging in the unauthorized practice of law. And that argument was probably made during the, during the case, but ultimately he lost, and then they ended up settling the case before he appealed it. But that idea is still on the books, that lawyers are somehow in this sort of interesting space, right? With regard to, do they have to be registered or not? And of course, the law, according to the Talent Agencies Act, would say, yeah, it applies to everybody. But of course, if you look at the legislative notes, maybe it's a little bit different. So where does that leave us? Well, ultimately, this law requires that you have to be registered to sort of broker these deals for talent. So one, it's to be aware of it if you're going to be brokering these deals in either Los Angeles or New York, the only two states that have this sort of law. But then it's also to understand the differences between agents and attorneys, right? Because as an agent, you really don't have limitations in terms of recruiting, other than making some notice and letting universities know that you're there. But as a lawyer, you have requirements that you cannot, specifically in California, you cannot have in-person contact with a prospective client without a prior personal relationship. And you can't use runners and cappers to go out and book these clients for you. And so this basically means you can't DM, an athlete and say, hey, I'd like to represent you, Now, look, is there ways to work through this? Absolutely. You befriend somebody without expectations, and that leads to a relationship, or somebody makes a genuine introduction for you that knows the person, and it's not a situation of a runner and a capper. And runners and cappers more typically apply to, let's say, like personal injury cases where you've got folks out there handing out business cards or looking to book, accident cases with lawyers. And I'm sure there's other things that occur in other industries that are similar to that. But as a lawyer, it's illegal, and it's a violation. And so, of course, we have to be cognizant of that as lawyers, but it's just interesting. And I think that it's something that, to pay attention to. So that's sort of where we stand. with regard to that. And we'll sort of see what sort of challenges come out of that from the talent agency's, ACT's perspective. So in looking at some other issues and sort of closing up, one of the big things that I've sort of seen in my practice, people ask me, how'd you get started? And I always go back and I say, look, I had a passion for entertainment, media, and sports. I grew up in Hollywood, grew up loving sports, playing sports, watching films and television. This was natural to me. I knew it. That being said, I came out of high school and college and really into law school wanting to be a district attorney, mainly from watching Law and Order episodes, thinking that this was going to be a great opportunity to do this. And, ultimately when I got into litigation in law school and worked for the public defender and, worked for these different, entities, civil litigation firms, I realized this is not for me. And I enjoy the theatrics of, being in court from an acting standpoint, because I'd done some acting as a kid in a couple different plays. A couple different plays, but ultimately, I think I enjoyed more of the relationships. I enjoyed more of the deal making, and that's why I became a deal making lawyer. Because to me, it was pretty straightforward that was what I was good at. I was good at peacemaking. I was good at deal making. I was not good at being combative or arguing or anything like that. I was good at making a deal. And I thought, why not put myself in that position? And I've really based my practice on 3 principles, which I've written about, talked about extensively. And it really comes down to geography, branding, and community. I have felt from the beginning that those 3 aspects are the most important in building a business. It's about, where you're at, and both digitally and physically, showing up, being there, having a presence online, having a presence in person. That is 90+% of it. Branding. Who are you when you leave the room? As Jeff Bezos would say, what is it that they say about you when you leave the room? And it's interesting because, branding is all about what you put out there. It's about, so I write a weekly column. I do a weekly podcast. I try to share on social media, 5 days a week, particularly on LinkedIn and the other platforms, with articles and helpful information. And I try to stay relevant. I read the trades. I, pay attention. And I think all those things help the brand. And I think being connected on social media and posting content and being active in different programs, I think really kind of creates a cyclical effect where people remember you and they call you for business. And it also keeps you apprised of what's happening in the industry. The last piece, so the first two were geography and branding. The last piece is community. This to me is essential. Joining organizations, bar associations, and not just joining, but taking on leadership opportunity, volunteering, putting work in. This is where you're going to meet lawyers. It's where you're going to train. You're going to learn more. And this applies to any industry, by the way. And that has been a recipe for success for me. Look, nothing's perfect, but it's definitely worked for me. And it's something I would encourage each of you to do sort of in your practices in terms of, really trying to build clientele. We live in a fascinating time where, you've got the NFL using sort of entertainment and music to gain more viewers, which highlights the point that entertainment and music are really sort of starting to combine in many ways. You have a lot of athletes that are acting as producers now and creating studios and production companies and selling content, creating content. Some of the biggest drivers of viewership now are sports documentaries. They go across many different quadrants of the populace because, ultimately, you're looking at, okay, somebody who's older, who's younger, who's male, who's female, can be interested in this because it's not just watching a sport, it's watching somebody's life inside of a sport, right? So very, very fascinating, what's sort of been happening. And we also live in a time where we have artificial intelligence. and we have data and sports gambling and all those things combined together, and what that can mean for the growth of sports. I don't know if we're going to be at a point where we're going to have, AI robots, playing sports, but it's not too far off to have some sort of robot league and people betting on it. And of course, I think as the generations go on, in some sense, they become more sensitive to, let's say, for example, and things become more vocalized because of social media and everything else going on. But let's say, like in horse racing, for example, horse racing and deaths in horse racing have always been an issue. But I think more so now, there's been a highlight more of those injuries. And I'm not sure the statistics on this as to whether injuries have increased over the years, but it's clearly become more prevalent of an issue. Thus, the mention of the sports league that I mentioned earlier, that had sort of grown, right? Sort of out of this point. And so as we look to the future, I guess, we live in a fascinating time. I think entertainment and sports is going to continue to grow. I think continue to adjust. We just had the first $700 million contract in baseball with Shohei Ohtani. We've had billion-dollar contracts with players like Cristiano Ronaldo and Lionel Messi. The growth of games. Cricket is clearly a growing sport. Pickleball is growing. It's just a very fascinating time, and just glad to be in it and glad to be able to experience it. And it's something that, look, each of you can do. This is just a matter of getting the clientele and working up some deals and being, being available, right? So to me, I think it's just really important. And by the way, I should call out that on my screen it says the Guam Bar Association. So it's still a U.S. territory, but obviously not the U.S. Virgin Islands. I did a similar presentation for Guam, and so we'll see if we can get that fixed. But at least on this video, probably it's going to be saying Guam. But folks, I really just appreciate you listening in and being a part of this presentation. I'm going to end it here. If you have any questions, feel free to reach out. My contact info is on the page there. And again, thank you again, and hope to, see you soon in the U.S. Virgin Islands. So we shall go from there. Okay, thank you so much. And since I'm recording this right before Christmas, happy holidays and Merry Christmas to all of you. So thank you so much.